work with Scotia Trust, which is the area of Scotia Bank, which provides what we commonly refer to as fiduciary services. All of the banks, although I work with Scotia Trust, I'm speaking really on behalf of all of the banks in that all of the banks have a trust company arm. And I realize that a lot of clients are not familiar with what the trust companies do. All of the, and this really hit me the other day. I was out talking to a few of our branches about some of the services that Scotia Trust offers. And I had to remind the retail staff that clients don't tend to come in to ask for these things. They don't tend to come in and say, can someone help me with my will? Can I appoint you as my power of attorney? What about your custody services? These are really a mystery to a lot of people. All of the banks advertise a lot, but trust companies do not. And we do have some special services that we are able to provide that the larger bank cannot. So what I want to talk to you primarily about today are some of the services that are available through the bank, but more importantly, my focus is on the importance of planning. Not everything in life can or goes according to plan. I always say the good news and the bad news is we don't know what's ahead of us. Life would be much easier to plan if we did know what was ahead of us, how long we were going to live, what our health would be like, how much money we need, etc. I don't think any of us would want to know that, however. So we do need to plan, as the title of my first slide suggests, planning for life and including life's uncertainties. There are certain things that we can do that would help prevent elder abuse simply by having the proper plan in place. So that's sort of the area that I want to focus on, the things that we can control. What I'm going to do is begin. My first few slides are the sort of presentation that I would give to any group on will and estate planning. I can tell you that statistically, 50% of Canadians die each year without having a valid will in place. Everyone should have a will. Most everyone acknowledges that. Occasionally I meet someone who says, who cares, I'll be dead. Most people realize the importance of doing a will. Often they don't see the urgency to doing it. Occasionally we get a call from a client who has all of a sudden it's just dawned on them that they're going to Europe for the next 3 months, tomorrow. Perhaps they should have a will. Or it's something to the effect of a neighbor had a heart attack shoveling snow last winter and that neighbor's the same age as them. So although most people realize the importance of doing this, the urgency is often not there. So I really encourage everyone to get around to doing this. From a perspective of someone who has practiced law in this area in a law firm and now works for a financial institution in this area, it is not pleasant for either the client or the person giving the advice and working with them to be dealing with someone where this is a reality. Every lawyer I know that works in this area has done what we refer to as deathbed wills. That is not fun for either the client or for the practitioner. A deathbed will. So someone that realizes, I'm not going to make it, I better get my will in shape. That's not the time you want to do it. You should get your will done while obviously you're still competent to do it. You can think clearly about what you want, you're healthy. You tuck it away, you take it out periodically to make sure it still reflects your wishes. Perhaps you've had a grandchild that you want to add, that sort of thing. But get your will done now, put it away, the peace of mind that that brings. This particular slide, this is my favorite, my little spider's web. And the point here is estate planning, yes, it's your will, but it's more than that. So most people know, yes, they need a will, but they're often not aware that other components form part of your estate plan. The reason that I have the spider's web analogy is if you were to touch any part of a spider's web, it would reverberate throughout the web. These are just some of the things that you need to look at along with your will and make sure that they complement each other, not contradict each other. An example of a contradiction could be if your will says you leave an RSP to someone, however, on the document itself, when you open the plan, you say you're leaving it to someone else. Quite often we see that sort of thing. So all of these things need to work together. Some of them I think are sort of obvious. So things like RSP, RIF, life insurance designations, that really is part of your estate plan because you can designate on that registered plan. We now have the tax-free savings accounts that you would put under this heading as well, to whom you want that asset to go. So clearly that's part of your estate plan. How you register your property, whether you own it outright, as tenants in common, or as joint tenants with rights of survivorship, that is part of your estate plan, because that registration affects what's going to happen to that asset on your death. I have a totally separate slide just on joint tenancy with right of survivorship, because in my view it's really being abused right now. I will come to that towards the end of the presentation. The two dependents relief legislation is an example of outside law that may affect what we're allowed to do in our will. So in Canada, we begin with what is known as freedom of testation. That essentially means that you're free to leave your assets wherever you want. And that's in contrast to certain other regimes. There's one called forced heirship. And when I first heard it, I thought airship, like A-I-R, ship, like a plane. It's airship, H-E-I-R, ship. An example is Sharia law is an example where the law dictates where your assets will go. I was working with a client who owned, lovely, nice problem to have, a little pied-à-terre in Paris. She told me that she had no choice. That asset had to go to her son. I don't know a lot about French law, but under French law, which would govern a piece of real estate in France, she had no choice where that particular asset was left. So in Canada, you can choose to leave all of your assets if you want to the Humane Society, for example. However, there may be a couple of groups who may have claims on your estate. The two primary groups are your spouse and or any dependents. Dependents has a fairly wide definition. I think the obvious one is if anyone passed away leaving minor children, but it can also extend to a parent if you were in fact supporting that parent at the time of your death. So you need to look at your will. Again, you can do what you want, but be cognizant those particular people may have a claim on your estate. And that's what a good estate planning lawyer will go through with you. Inter vivos trusts are something that we're also starting to see more of, and I'm going to talk particularly to this group about what are known as alter ego and joint partner trusts, a type of trust that can come in very handy in this area, and obviously powers of attorney are something I want to address. So again, this is a typical slide I would go through. Here's what you want your estate plan to do. No matter whom you're leaving your assets to, for most of us it's family, for some people it also includes friends, for others it's exclusively to charity or also to charity. Wherever you're leaving your money, you want to pass on as much as possible. The way we pass on as much as possible is by minimizing the associated costs. So two of the things that we'd like to look at in good estate planning is how we can potentially minimize the income taxes involved and also the probate fees. You want to, and I will speak a little bit more in detail about those, you want to reduce the burden on your family simply by having a good plan in place. Where an estate where the will is improper or there is no will, means someone has just died, there's enough other stuff going on, grief, often there's been a lengthy illness before that. At least make things easier for your family by having a plan in place, let them know what you wanted with respect to any healthcare wishes, funeral arrangements, and also have a will that does not then cause problems. See, all the time that discussion of the sandbox issues, believe me, they come roaring back at the time of a parent's death. The only way to assure a continuation of your values is to put this information in writing. And I'm talking about if you have particular issues with respect to healthcare, you can document those. And also, the only way to make sure your assets go where you want is to have it properly documented in your will. The two things that I highlighted at the end of this slide for purposes of this discussion, to include a plan for the unexpected, and what I mean primarily with that is having powers of attorney. We all know, as the first speaker said, we are all going to die. I lost my mom about 10 years ago, and she used to always say to me, if I die, and I said, Mom, I hope it's a long ways away, but that's the big when. It's not an if. What we hope does not happen prior to that is that we lose our capacity. But it can happen, and you can't wait until it happens to plan for it. So you need that plan for the unexpected. And the other part of that is I find it interesting is people often come in, they know what they want to have happen to their will in the first instance. Often it's, to my spouse and then over to my kids. And then if you said, what would you want to have happen if a child predeceased you? I can't imagine anything worse in life than having a child predecease you, but sometimes it happens. So, strange way to put it perhaps, but people don't always die in the right order. So a good will address those potential contingencies to make sure that all of the bases are covered and that you do have a plan that makes sense now and into the foreseeable future. All of that, I think, if you added all those up, is going to bring peace of mind. This phrase, start at the end, is really my view of estate planning. I don't know that every estate practitioner shares it, but I see too many people that come in and they say, how do I plan this to save probate fees? How do I plan this to reduce income tax? And I had an example. We work a lot with our investment advisors throughout the bank, and it was a Scotia McLeod advisor called me to say, how can my client save income tax by leaving money to charity? And I said, oh, that's wonderful. Has your client expressed charitable philanthropic intentions? Well, no, but he wants to save taxes. Well, that's not how it should work. If indeed your client has charitable intentions, and that's absolutely wonderful, we then work backward to find the best way to facilitate that gift. Don't ever let your probate planning or tax planning be the tail that wags the dog. Start at the end. Whom or what, in terms of charities, would you like to benefit? Work backward to find the best way to do it. I'll give an example. My own situation, I have a husband, I have 2 teenage boys. I know I want to leave money first to my husband, and then on the death of the survivor of us, I would like the money to go to my boys. However, I don't want the money to go outright to my boys. So I already knew to whom I want the assets to go, but I then have to look at the best way to do that, and in my case, that would be establishing trusts. And I'll talk about trusts in a moment as well. So you would identify things like, are there minor beneficiaries? Is there a beneficiary with an issue? Such as they have an unstable marriage, perhaps they've started their own company and creditor protection's an issue, or they're receiving now or may in the future receive government benefits or special planning we can do called a Henson Trust, which would ensure entitlement to those benefits continue. So again, working backward to find the best way to plan your estate. Sometimes I find the best way to convince people, if they need convincing to get around to doing that will, is to let them know what happens if they don't do a will. Each province has their own formula of what will happen to your assets if you die either without a will or a will that for some reason is found not to be a valid will. And your will could be invalid, for example, if it wasn't properly witnessed. There's a number of reasons why wills can be found to be invalid. So if you die intestate without a valid will, then in Ontario, we're under the Succession Law Reform Act, and there are certain formulas. So if you were to die and you left just a spouse, your spouse would get everything. If you left a spouse and more than one child, your spouse would get the first $200,000 of assets in your name. Anything left beyond that would be split 50-50, spouse and child. 2 or more children, spouse gets first $200,000 plus 1/3, children share 2/3. No spouse, all to your kids. No kids, it would all go to your parents if they're surviving. No parents, it goes to your siblings. Then it would go to your nieces and nephews if there's no siblings. People sometimes say, oh, if you die without a will, it all goes to the government. Ultimately, it could if you left no next of kin anywhere in the world. I've occasionally had someone say, well, that doesn't sound bad. Why should I pay a few $100 to get a will? That's okay. It's always more expensive to administer an intestate will. There's nobody to start administering this. You haven't named an executor. Someone needs to go to court to be appointed. And quite often the formula just isn't what people would want. In my case, my husband would get the money and part would be shared by the boys. I would not have established trusts for them. So what happens is any money that would be going to them would be paid into court, and worse yet, all of it, and whatever it is, and like most of you in this room, I will be worth more dead than alive when you think of things like life insurance coming in and all of your RSPs now being available, then all of the money would be paid out to them at age 19. I've never done a will for anyone that wants their children to get their money at age 19. The first place 2 boys would go, I know, is to a car dealership. So the only way for me to establish those trusts is to do a valid will. I have one turned 19 a couple of months ago, but I would still need a guardian for my 16-year-old, and the only place to appoint a guardian is in your will, so I'd lose the ability to do that. I can't do any tax or probate planning, and trusts, again, are part of tax planning, and most importantly, I'd lose the ability to choose my executor. So those are all the things that you lose by not having this valid will in place. So talking a bit about the right executor. Your executor and your attorney are 2 of these people in a position of trust. And it's very, very important that you choose the right executor. Most people by default just name their spouse and then their children, if that's how their family's structured, or they'll name another friend or relative. They don't at all think about what's involved in the role or even the potential burden that they're handing this person. There is a lot to do in administering an estate. There's been a few studies that show even where it's an outright distribution, and by that I mean there are no ongoing trusts, it will take a minimum of 2 years, often longer, to administer that estate. It's not 2 years of solid work for the executor, but they're essentially on the hook for that period. And the reason it can take that long is, for most estates, you will require to, except for perhaps the death of the first spouse, where most of your assets are going to be jointly held. In any other instance, you will likely need to have that will probated, and probate is not a bad thing. That can take a few weeks, however, and on the other end, you should not be distributing all of the assets until you get clearance from the Canada Revenue Agency, because only then are you off the hook as executor in terms of taxes. That can take many months to get that clearance certificate. So it can be a very long-term job. If there's something that can go wrong in an estate, something seems to go wrong in an estate. And often there's just, whether it's family conflict, sometimes it's just geography. People are living all over the place now. You know, it's not at all uncommon to find children that no longer live around the corner from their parents. Administering an estate is not a job that you can do online. Everybody lives somewhere when they pass away. It could be one room in a retirement home. It could also be the family home where you have 75 years worth of stuff. Somebody's got to deal with that. You likely have to visit the bank. There may be a safe deposit box, etc. There's a lot of work involved in administering an estate. Some of it is just, you know, mundane sort of work, calling government offices, canceling a driver's license, that sort of thing. Some is a lot more complicated. There's a lot of tax work involved in estates, and there can also be special record keeping for beneficiaries, etc. So the person you need needs expertise. I taught the bar admission course section of estates for a number of years, and this area of law somehow, it's gained the reputation of being kind of easy, and the students would also often come in thinking, oh good, we just do estates for a couple of weeks now, that'll be so much easier than tax or whatever. The first day you give out a page showing the number of the amount of legislation that affects estates, and there's something like 24 pieces of legislation, and in addition to specific estates legislation such as the Succession Law Reform Act, Substitute Decisions Act, Estates Act, Estate Administration Act, you need to know about income tax, you need to know about property law, about family law, dependence law. It is a very complicated area. You need to be available. As I say, it can take quite a while. Met with a gentleman once. He said, well, this is all good. I've appointed my daughter as executor. She's a teacher. And I said, oh, are you planning on dying on June 29th? Like, that would work out very well. Aside from that, teachers have among the least flexible schedules. And he said, I never thought about that. Financial accountability, trustworthiness, good judgment. There's a lot of money for many people at stake. There's decisions to be made. When do we sell an asset? What do we invest in? And executors have power. They are in control of those assets pending distribution, and unfortunately, fraud happens. One of the fastest growing areas of law in downtown Toronto is estate litigation. I was called to the bar in 1989. All of the large law firms did estate litigation. They would have a litigator that handled this. There are now 3 firms I can think of off the top of my head that we deal with that do exclusively estate litigation, and those firms are growing in leaps and bounds. People are getting more litigious. They're fighting over this stuff. You can't necessarily prevent a fight. However, good planning can certainly help minimize the chances that there will be. So the people that say up front, oh, why pay a lawyer a few $100 to do a will? I often say you can pay me now or pay me later. Impartiality and longevity can be issues depending if there's long-term trusts, for example, or there's a potential sort of 2 families, there's stepchildren, spouse from a first marriage. Sometimes that independence is also very important. So talking very quickly about trusts, 2 basic types. Inter vivos are trusts that are set up during your lifetime. Testamentary are trusts that are established in your will. In Canada, we don't see a lot of inter vivos trusts, primarily because there are tax disincentives to these sort of trusts. It's all good news with testamentary trusts. So again, a trust for a minor, a trust for a spouse, for a disabled beneficiary, a Henson trust. Those are all the sort of things that you may want to look into. I'm going to go through this very quickly because the presentation will be available, and I'm pleased to answer questions or get in contact later. I just want to give a very high-level overview and focus more, again, on the planning part and the things you can do to protect yourself. The one thing to know about trusts that I've highlighted at the end is we're starting to see more people think of trusts for protection, these inter vivos trusts, alter ego or joint partner. It is possible, if you're over age 65, to establish one of these trusts. There's no tax disincentives, so you can put all of your assets into it without having to pay income tax. You appoint a trustee who is then in control of those assets, and it can give you protection. No one else can get at them, and I'm talking about whether it's your children, whether it's other scam artists, caregivers, or whatever. There's certainly something that people may want to consider in addition to a power of attorney. Looking at powers of attorney, 2 basic types. And everyone should do a power of attorney along with their will. Our powers of attorney laws changed in 1990, I think it was 93, when the Substitute Decisions Act came in, and there was there was seminars at the time and all sorts of interest. Powers of attorney are no more important now than they were prior to 1993, but they got an increased focus. So my guess is there's a chance that anyone who did a will prior to 1992-93 may not have done powers of attorney at the time. Most people who have done them since, if you went to a good estate planning lawyer, not just someone that does real estate and the odd will on the side, you should have powers of attorney in place. They should, it's a good thing to review them periodically. So the 2 types are for property management, and what did become new with the new laws is this power of attorney for personal care. It's an official power of attorney where you can appoint someone to make these decisions for you. Prior to that, we had, I'm sure you've all heard of living wills. Those were something that they were not legally binding. You could put down if you had particular wishes, such as, we use phrases like you don't want to be kept alive artificially, no heroic measures, you don't want blood transfusions. It was not legally binding, but it would give guidance to the physician that was looking after you at the time. And I can tell you, having been through this with both of my parents, how valuable they were really depended on the doctor. I've heard some doctors say this is meaningless, I need to have something legal in writing. There's something called an advanced healthcare directive, which essentially goes through every body part and organ and says what you'd want to have happen. If it was your liver that failed, what do you want to have happen? If it's your kidneys, if you're this and that. Most people don't go to those lengths, but what you can do with this power of attorney for personal care is appoint someone to make, and I'm focusing on health care, but it concerns other things such as housing, which is a big one. It's your personal care power of attorney that would make a decision with respect to if you ever needed to go into a nursing home, things like nutrition, but again, the health care. This power of attorney can only be used if and when you become incapable of making your own decisions. So clearly, if you can make these decisions, doctors want to speak with you directly. The contrast is the power of attorney for personal care is effective the moment you sign it. It is a very powerful document, more powerful than your will. A will has no force or effect until you pass away. Nobody can do anything with it. You're free to change it whenever you want, so long as you still have the capacity to change it. Not true of your power of attorney. The moment you sign that, someone can use it. And I can tell you, they do use it and they do abuse it. I have another seminar that I do only on powers of attorney, and what I did for a period of about a month, I just monitored headlines. And I'm not talking about the legal documents or reviews that I get. Things like Maclean's Magazine, the Globe and Mail, the Toronto Star, and titles like theft by a power of attorney, abuse by a power of attorney, abuse under joint tenancy. Unfortunately, these things are happening, but there are things you can do to make sure that they don't happen to you. The first and foremost thing is to choose an attorney that you trust implicitly. This person is going to have a lot of authority, and they actually have control of your assets. They have the power to sell your house. They have the power to close your bank accounts, to take money out of your accounts. It may indeed be fraud or theft. It may interest you to know there's a section of the criminal code called theft by a power of attorney. There's got to be a lot of action to get your own section of the criminal code. This stuff happens. So yes, it's illegal. You could go after these people. That doesn't do much good if they've absconded with your money. So make sure that you choose someone that you trust implicitly. And sometimes that is choosing a trust company. With both your executor and your attorney, you have 2 options. You either name an individual or you name a trust company. And again, all of the banks have a trust company arm. We are the only corporate entities that are able to act. Clearly, there's going to be a lot of protection when you appoint one of these. We have all sorts of legislation that governs us. No decisions are made by one individual, etc. So sometimes that is the best option. There are also other services out there. We have something called personal office that I often refer to as power of attorney light. Sometimes we get clients who, they have capacity, but either it's becoming too difficult for them, and sometimes we see it, and sexist as this may sound, often we had the husband who just looked after everything. And I can think of a very good example we had recently. He loved playing the stock market. He had his advisor, just loved to look at all this stuff. He knew he was terminally ill. His wife was a very, very bright woman. She'd had a good career. She said, I just don't care about any of this. It's not what I want to spend my time on. She says, I want someone to send me a check every month. So again, it wasn't any lack of intelligence. She just had no interest in this. So we have a service where we can do everything for you. We can gather all your assets. Some people have them far-flung, all these different banks. Sometimes people have them all in one place. Make sure that your GICs are renewed. Make sure that your assets are properly managed for you. Do all of your tax work, etc. I call it power of attorney light because occasionally we have clients who you can pick up reluctance. Their children are maybe starting to push them, saying, Mom, don't you think maybe I should start acting under that power of attorney? Sometimes it's for totally legitimate reasons. They're a little concerned that you're not up to the task anymore. Sometimes it's for more nefarious reasons. They would like to get at the money. But how nice it would be if you could just say, you know what, everything's in order. I don't need to worry. My GICs are taken care of. I never miss a renewal. My taxes are done, etc. Thanks for the help, but everything's okay. And sometimes we get clients that just travel a lot and they just don't want to be bothered with it. So it's more to be aware that there are options such as a product like personal office, and then you can also name the executor and the attorney to be the trust company. And often people do not want their power of attorney used until they become incapable. So I said, it's effective the moment you sign it. That's true, but there are precautions you can put around that. So A, choose someone that you trust implicitly, but B, you can add a level of protection. And what we do at the trust company is your document has no restrictions in it. It says, I appoint the Bank of Nova Scotia Trust Company. So we could use that at any time. But what we do is have you sign what we call a letter of authorization and direction. And this protects both sides. And what it says is, I only want you to use this document under the following circumstances. And number one is if I ask you to start acting. Best example, we had a woman call the trust branch in Toronto one day. She said, to paraphrase, I'm getting old and tired and could use some help. And I thought, yeah, you and me both. She wanted us to start acting. She was fine. She liked to travel, just couldn't be bothered with this. So we started acting as her attorney, although she was completely capable. The second choice is if these people tell you to start acting. And often those people will be children. Sometimes, however, we get appointed because there are no children either around, or there are no children, period, or other relatives who would be appropriate. So the third thing is often if one or more physicians say, and the phrase that it tends to be is, Elaine could use help managing her affairs. Doctors don't want to get into the technical thing of you are incapable of managing your property because that gets into a legal test. Assessors may need to be called in, etc. You can require that stringency. People are normally happy to have, and you can name the doctor. It can be your current physician, or it could be any physicians that are currently looking after you. If they say, and again, you can make it just one, two, or more, say you could use help managing your affairs. At that point, we will step in and start acting for you. We would have no reason to go in before that, so you know that A, we will act when we need to start acting, but we will not act before that. It is also possible to put these restrictions in if you name a family member. So some lawyers may raise this. You do the document, you've named your son and daughter, for example. You will ask the law firm to hold that document and only release it under certain circumstances. I encourage clients not to put those restrictions in the document itself. So any of you that have powers of attorney, if you want to go home and take a look, it's better not to have a restriction that says, Mary can only use this power of attorney if Elaine becomes incapable. Because the problem is when you go to the bank or you want to deal with property registry office or whatever, they're going to say this is not effective unless you can prove Elaine's incapable. They're going to want documentation and evidence of that. So just in terms of making it smoother process to deal with it, keep the document clean, but you can have these side documents that restrict its use. But the main thing to know is that this is indeed a powerful document. I see there's people that don't even think of it's abuse. I know they don't think it's abuse because I've heard, even friends say, well, I'm mom's power of attorney. Why would I need a new car. Why would I get a bank loan? I'm getting all her money anyway. So they see no problem with dipping in and taking $10,000, $20,000 because they're going to get it later anyway. That is theft. It's not their money. They need to be managing that money for their parent. That money needs to be there for their care. And you know what? At the time of the mom's death, if there happens to be any money left, maybe they're going to get it, but it is not theirs to touch at the time. And others, it's much less innocent. They know what they're doing, and they are actually stealing the money. And we see this, unfortunately, day and daily. So if you don't have powers of attorney and you do become incapable of managing property, no one has any authority to deal with your asset. So you need to go to court. It's a very complicated process. Someone needs to be appointed as your guardian of your person and also of your property. They need to file a management plan where they go through all of your assets and say what they're going to do with it. It is not a good process whatsoever. So definitely you need to get powers of attorney in place up front. And if you don't have them, the public guardian and trustee will get involved, which is not a bad thing. It just complicates the process. Choosing the right attorney, if anybody remembers several slides back, these are exactly the same things that I said for choosing the executor. There is no law that says your attorney must be the same person as your executor. Generally, it just makes sense. You're looking for all the same attributes, so why would you not choose the same person? Financial accountability, trustworthiness, etc. There can also be benefits in terms of the cost. Attorneys can charge for their work, as can executors. If you name the same person to do both jobs and your attorney did act, again, we're hoping this is the document that grows cobwebs and is never used, but if someone, so let's take the situation at the bank, if we begin acting as someone's attorney, we charge, there are rates set out in the Substitute Decisions Act, the client passes away, and then we're also acting as their executor, we do not take full fees as executor, because we already have control of the assets and have done some of the work. So there's also can be a financial reason for appointing the same person. If you had two different people doing these roles, your attorney could take full fees and then your executor also take full fees. And the longevity is important. I mean, again, it can take a couple of years to wrap up an estate. You begin acting as someone's attorney for property, that could potentially go on. If someone's terminally ill, you may know it's a job that's going to run a few weeks, a few months. If it's someone with some form of dementia, for example, this might run for years. It could run for decades. No one is obliged to take on the role. So if someone says, do you want to be my attorney? You have the choice up front to say no. However, once you're involved, you may need to go to court to be removed. So if it proves to be too difficult, you're having trouble, you cannot easily get out of this job. So quickly on this joint tenancy with rights of survivorship. First of all, I'm hoping the problem will go away because there are pending changes to, I keep saying probate fees, they are technically now called estate administration tax in Ontario, but people tend to still use probate fees. There are pending regulations coming out where the government has suggested they are going to require you to report and pay probate fees on certain joint assets. And it will likely be those assets that are not held joint with a spouse. That situation is usually fine. So where we're running into problems with joint tenancy, it's a very common technique. I would normally recommend it between spouses, at least in a first marriage situation where there's not two sets of kids to worry about, and if there's no other issues such as capacity or creditor issues. So take my husband and I, our house is joint, designated each other on RSPs, life insurance, we have a joint bank account. On the death of the first of us, it is relatively easy to administer that estate. The things where I've designated him as beneficiary, he would automatically get them. You just need to submit a death certificate, let the people know. The joint accounts would go to him. However, where we've started to see problems, and I filed this under a little knowledge is a dangerous thing, is, and I'll take my husband's situation. He's one of 8. He's the primary caregiver for his mother, who now has dementia. This was several years ago before she did. His dad passed away. Go to the bank, and the well-meaning person in the bank said, oh, why don't you make this account joint with your son? And she's thinking, great, why not? He's the one that does most of the banking for her, takes her to the hairdresser, does the grocery shopping, and the well-meaning person in the bank said, oh, and you'll avoid probate. And people are quite obsessed with avoiding probate. What she didn't go on to say was all of the potential downsides to doing this. The first is, if that was what we call a capital asset, something where you may have capital gains, and that would be something like a cottage or an investment account, then when she added his name, there would be income taxes due on that. Nobody tells her that. If it was her home that his name was added to, she would lose half of the principal residence exemption. He doesn't live there. It's not his principal residence. If something was to happen to our marriage, there's an asset with his name on it that my lawyer, I can guarantee you, would tell me to go after. All sorts of reasons why you perhaps should not do this. And the most important is you may not avoid probate, which is the whole reason for doing it. And the reason is, and people are surprised to hear, that the Supreme Court of Canada has heard cases on joint tenancy. I mean, who knew it was that important? The Supreme Court of Canada chooses to hear cases that are of national importance or significance. And what happens is exactly that situation, and then mom passes away. The question is, between the bank and my husband, the bank is fully entitled to pay the money to him, the surviving joint holder. The question is it his money to keep, or is he holding it in trust for the estate? And just very quickly, because this makes great cocktail party talk with your friends, two presumptions come up. He's either holding it under the presumption of resulting trust or the presumption of advancement. Which of those two presumptions applies depends on the surviving joint holder's relationship to the deceased. So where the surviving joint holder is a spouse, you're presumed to hold it on the presumption of advancement, which means it's yours to keep. Where the surviving joint owner is an adult child, they are presumed to be holding it in trust for the estate, meaning they should share it with the other beneficiaries in the will. Whenever at law we have presumptions, they can be rebutted by evidence. Whenever we're talking about presenting evidence, you're either in court or in front of a lawyer. And I can guarantee you either way, whatever money you thought you were going to save in probate fees is long gone in legal fees. So there are so many downsides to doing it that it is just not worth it. And probate has some protection. It guarantees you that it's the last will. You, the executor, are not going to be in trouble if something happens later. Just be very, very careful with doing this. And I think when the new rules come out, there's going to be no benefit to doing it at all.
What are the new rules coming out?
We wish we knew. And it seems at all levels of government, there's a few other things going on that are holding things up. Certain changes were effective on January 1st of this year, but the regulations that actually specify these sort of things in terms of what you need to file, they've also moved the probate fees area into another part of the government where there are now audit facilities. So what probate is, to just, because I talk about it like everybody knows what it is, probate is taking the original will, the named executor in the will swears an affidavit containing certain facts, name of the deceased, where they resided at the time of death, and the value of the estate. Sometimes that's simple. Someone had a bank account and you get a quick appraisal on the house. It can be much more complicated if there was a private company, a farm, or something like that. So people have said, well, who knows? Who's going to check this? My answer always was, you are swearing a legal affidavit. So as an executor, I'd make sure I'm saying the right thing. Quite frankly, I don't know that they ever were audited. They're going to start to be audited. And they can go back several years. One more reason not to be an executor. So most of what I've said today, I think I'm getting you thinking about who you've named as executor, if they're the right choice. Also think about if somebody's named you, if you want to take it on. It can be a thankless job, and again, it gets more complicated all the time. Perhaps all I need to say is you can actually take out insurance for being an executor. There's an insurance company out of Kitchener that now offers executors insurance. So my thought is, if this is a job you might actually want to take out insurance to do, perhaps it's a job that you don't want to do. So people that say they've made something joint for convenience, just let me tell you, there is no such concept at law as for convenience. That's why we have powers of attorney. So I'd recommend strongly against putting assets joint, especially if you have more than one child. Sometimes I'm a little too black and white. I did a seminar once where mother and daughter came up to me after. The daughter said, oh, you've got us all worried now. She said, I live with my mom. She says, I'm not married. I likely never will be married. I have no children. I have no creditors. We share all the expenses. Doesn't it make sense for us to have everything joint? And indeed it did. That was more akin to a spousal relationship. Totally made sense. It will simplify the estate. However, the one thing they need to think about, when I said earlier, people don't always die in the right order. They were certainly assuming all along that mom would die and daughter would get it all. Mom would have to do some different estate planning if the daughter predeceased her, because it wouldn't work out in that way. So I think the point is just be very, very careful before ever making anything joint. That person has authority over that account along with you. Kids have cleaned out the accounts using this joint. And, we'll hear banks don't do enough. They don't protect. I don't know what we would think the banks would do. If you were to walk up with your son who clearly was pushing you and bullying you to take money out, the bank would probably not allow them to do it. You can do things online now. You can do them at the machines. The way the world has evolved, there's absolutely no way that we can expect the banks to have full oversight over this. So it really, really is incumbent on all of us to make sure that we do the proper planning, choose the people that we trust to take on these roles. So I have learned that no matter how many things I say in a presentation, how many things anybody says, people will remember 3 things. So let me recap the 3 things I would really, really like you to remember, and then hopefully we have a few minutes for questions. Proper planning can help minimize your risk. It can do a number of things, as I said at the first slide. Make peace of mind for you, get everything in order, make sure your assets go where you want. It can also really, really reduce the odds that you will ever be taken advantage of financially. Make sure that you choose, part of this planning is to choose the right executor and attorney. They have a lot of power. These documents that you give them can be abused, so it's really, really important that you choose somebody that you can trust. I've suggested that it's either a family member or a trust company. There's also the option of having joint. We are often appointed in situations along with a family member. So often it's billed as we're there to do all the administrative work, take off the burden, etc. Part of it is you've got that professional oversight as well. A document is very unlikely to be abused if the trust company is named along with an individual. And the third point is just don't take dangerous shortcuts. You may think that just making things joint is a good way to settle your estate, and it really isn't. A proper estate plan that looks at all of the things that are on the spider's web is really important to make sure that everything happens the way that you want to have it happen and that you're protected along the way. Yes, ma'am.
If you, can you name, say, 3, if you have 3 or 4 children or something like that, can you name all of them executors, 3 to work at any given time, or 2 to work, or?
No.
Is that?
So let's start with executor. So the question is, if you have more than one child, could you name 3 or 4 children to be your executor? At law, there is no limit to the number of executors that you may name, but there's a couple of things to keep in mind. First of all, if your executor resides outside of the Commonwealth, they may be required to post a bond before they can act. So it's interesting that the Commonwealth is still an issue in some of our laws. So you could have an executor that lives in Australia, which I'm pretty sure is still part of the Commonwealth. They were thinking about it recently. They would not need to post a bond, but your kid that lives across the border in Buffalo would. So, and if there's ongoing trusts, it can also affect the tax residence of the trust. So legally you can appoint them. You probably wouldn't want to appoint them. Where you name 2 or more executors, they must act unanimously unless the will says otherwise. So everybody has to be involved in the work, but you can say that a majority can make decisions. So that's pros and cons. If you require unanimity, then there's more protection because they all have to agree on a step, but it's a little more inflexible. And I can guarantee you, from my years of doing this, if your kids don't get along when you're alive, they're not going to get along when you pass away. So it's more, legally is one thing, but logistically and practically is another. A little bit different with powers of attorney. Again, you can name how many you want. You have the option of naming them what we call jointly or jointly and severally. So if I was to appoint, so let's just say it's my 2 kids, Connor and Austin, if I say jointly, then they must do everything together. So the bank would require both of them to sign off on any transaction, make any trades or whatever. If I said jointly and severally, the bank could take instructions from either of them. So again, it depends on your situation. I have more protection if both of them need to agree on something. But think about the situation. What if I had one that traveled a lot, wasn't easy to get a hold of, etc.? I may want the flexibility. So again, it's really just understanding your options and how they make sense in your particular case. Yes?
I'd like to know what the costs involved are in involving the trust company, first of all, to do the planning, and secondly, if you appoint them as an executor. And I realise that if you do the planning and you do not appoint them as the executor, there may be a difference in the fees. So I'd like to know a little bit about those kind of costs.
So the question is, and I'll expand it to what executors in general can charge, but what trust companies would charge to be involved in these roles. Starting first of all executors at law are entitled to compensation. It's not a set law. It's a little more complicated. In Ontario, there is something called the court-recognized tariff. That is the amount that a court would award an executor for administering an estate of average complexity. Enough gray words in there that it can go up, it can go down. It's approximately 5% of the value of the estate. Being lawyers, we make it more complicated. It's actually 2.5% of each of capital receipts and disbursements, and you have to keep proper accounts showing that division of the assets. Where a trust company is involved, we use a fee agreement. And sorry, that 5% applies whether you're a professional trust company or an individual that's never done it before. There's not separate rates. Where we are involved, we have clients sign a fee agreement. So we don't wait and rely on the legislation. We discuss fees with you up front. You sign the agreement. It's actually a legally binding part of your will. Our top rate, and the trust companies vary a little, but not a lot. Our fees are slightly different. Our top rate is 4.5%, and it's 4.5% on the first $500,000 of assets in your estate, 4% on the next $500,000, and it goes down from there. So it'll be a maximum of 4.5%. That's for administering the estate, the executor's fee. That's a one-time fee. If there are ongoing trusts, so say you establish a trust for a child, a grandchild, a spouse, there is then an annual fee for running that trust. About 1.5% is the top rate, and that includes us managing the money, the investment portion. But for most people, it's an outright distribution, so you'd have that fund. We do not do will and estate planning unless you're appointing us. So we have, our best clients are mature, wealthy, and I say wealthier, but we will take an estate that's $500,000 in total, and that would include your real estate. So don't think also that trust companies are only after the multi-millionaires. We love those, and we have some of those. We often have much more basic estates. Anyone in Toronto that's going to die with a paid-off house, believe me, qualifies for our services. We will meet with a client who, A, qualifies on age and assets. And the reason we want to work only with older clients is we don't charge for the planning work, and we keep those appointments. It's not sort of the obvious, or what we think is the obvious reason is if you're older, you're closer to dying. The more important reason is you need us, and we keep those appointments. And again, I give my own situation. I have named the trust company to act as what we call alternate executor. I've named my husband as executor, he's named me. However, if something happened to us both prematurely, and I like to say yesterday as opposed to tomorrow, I know what's involved in administering an estate. I would absolutely not give that to anyone in our family. So I've named the trust company. My cousin, my kids will be on a farm in Port Perry if something happened to us. They'll look after the personal side. The trust company will look after all the business side. But I'm not worth spending any time on, because I am hoping that my boys will continue to grow up, get along, be all of those things, be financially savvy, trustworthy, etc., and they'll do it. So spending time on someone like me where it's a good just in case, that reason's going to change. However, if you are 65, 70, and you want to appoint the trust company, your reason is not going to change. You have a child, we have a disproportionate number of clients where they have a child with a disability, and the major concern is I'm happy to look after this child with whatever the issue is during my lifetime. What is going to happen if the child survives me? So we have a number of situations like that, or complex family situations where there's the second marriage situation or whatever, or the assets are complicated, there's a private business, or there's just no kids around. They live out of the country or whatever. Where, again, a more mature client has those situations, those are unlikely to change. We're told that people usually change their will 2 or 3 times during their lifetime. We want to be in on that last final will. So we charge nothing for the planning. We have coast-to-coast will and estate planners, and I know the number because I'm having them all in Toronto next week, 26 will and estate planners from Victoria to St. John's. They meet with clients who want to appoint the trust company. They would talk a lot about the stuff I just talked about. We would take your will instructions. We would give you some suggestions of how you might want to manage assets. Anyone that's interested in philanthropy, we have the largest charitable philanthropic expertise at Scotia Trust. We do not draft the wills. I'm a lawyer. Most of our will and estate planners are lawyers. We do not actually draft the wills. We want an independent lawyer out there to do the drafting. We work with that lawyer to make sure everything's okay. All of that is complimentary. We hold the will in safekeeping. We keep in touch with you. If the law ever changed, and I've seen this once in all of my time, and that was 1986, so I can suggest that anyone that has a will older than 1986 probably wants to add a clause to their will, which is our Family Law Act clause. The law doesn't change much, your personal circumstances may, but we touch base to say, hey, is your will still up to date? Are you happy with it? We don't charge anything until you pass away, and we act as executor. And it would be under that fee agreement that, yes. And we can also be named as your attorney. We cannot be an attorney for personal care. Only individuals can do that. We could be named as your attorney for property. Again, hopefully we'd never need to act, but if the time came, we could act as that and then move into our role as executor.
Do you charge a fee every time, say you're a joint executor with a family member?
Yes.
You charge a yearly fee, and then every time you have to speak to that other executor, you charge a fee?
No. First of all, our fee agreement says it's our fee. So if you wanted that joint person to get more money, you'd need to negotiate with them. The reason is it's actually more work for us to have someone we have to consult with, and there's still the same liability. Executors' fees are a one-time fee. So, and that's, and it's different if you compare sometimes how lawyers work. They may charge hourly. So yes, consulting with the executor may indeed be an hourly charge for them. But no, it's a one-time fee. It doesn't matter how much consulting or anything else that you do. And I'm told that's it. I will be around for a little bit if there's a break later, and we can get in touch later if there's further questions. Thanks, Mary.